Your LLC does not protect you. Not automatically. And most business owners discover that only after a judge has already let a creditor come after their house. Right now, thousands of LLC owners are sitting on a ticking legal time bomb. They paid the filing fee, received the certificate, and assumed the job was finished. It was not. There are 5 specific mistakes that courts have used repeatedly to legally collapse LLC protection, and number 3 is the one that catches even experienced business owners completely off guard. These are the 5 mistakes we are covering today. Each one is a documented legal theory that plaintiff attorneys use to pierce the corporate veil. The legal phrase for when a judge decides your LLC does not deserve its own separate legal identity. When that happens, your personal bank account, your home, and your retirement savings all become reachable. Every one of these mistakes is preventable. Most of them are already happening to someone watching this right now. Mistake number 1 is commingling funds. This means mixing your personal money with your business money. Sounds like a bookkeeping issue. It is not. It is a legal argument, and it is one of the most effective arguments a plaintiff's attorney can make against your LLC. During litigation, a plaintiff's attorney will subpoena your bank records and go through every transaction looking for exactly this kind of crossover. One personal grocery run charged to your LLC account becomes a highlighted exhibit in a courtroom. The fix is straightforward. Open a dedicated business checking account and use it exclusively for business. Pay yourself through a defined salary or owner's draw, but never let the 2 pools of money touch each other. Legal analyses of veil-piercing cases consistently show that commingling appears in roughly 70% of the cases where LLC protection was removed by a court. That is not a coincidence. That is judges examining the same pattern of behavior and reaching the same conclusion. If you did not treat this as a separate business entity, there is no reason the court should either. Mistake number 2 is one that an alarming number of LLC owners skip entirely because they believe they can get to it later. Courts have made clear in case after case that later is too late. An operating agreement defines how your LLC actually functions, who owns what percentage, how decisions are made, what happens when a member wants to exit, and how profits are distributed. Without it, a court can argue that your LLC was never a real, functioning, separate business to begin with. The absence of an operating agreement is not just a procedural gap. It is evidence handed directly to the opposing attorney. For single-member LLCs, meaning you are the sole owner, the operating agreement matters even more than it does in a multi-member structure. Courts in multiple states have ruled that without a functioning operating agreement, there was no meaningful legal separation between the owner and the business. That single ruling collapses the entire protection structure you built the LLC to create. Draft the agreement, have an attorney review it, then actually follow it when making business decisions. We are 3 mistakes in, and I want to pause here. Everything I am covering today is correctable before a lawsuit happens. But the moment litigation begins, your ability to fix these issues narrows dramatically. Courts evaluate what you did before the dispute, not what you scramble to repair after it. Mistake number 3 specifically targets single-member LLC owners, and it involves a legal mechanism called the charging order, the protection that is supposed to prevent personal creditors from reaching your LLC membership interest. In certain states, that protection has a significant gap that most attorneys do not mention unless you ask the exact right question. In a multi-member LLC, a personal creditor who wins a judgment against you can typically only obtain a charging order. That means they can receive distributions if the LLC makes them, but they cannot take over your ownership stake in the company. The problem is that several states, including California and Colorado, have allowed courts to go further with single-member LLCs and grant creditors the ability to foreclose on the membership interest entirely, effectively handing control of your business to a debt collector. This is not a uniform national rule. Some states have enacted strong statutory language specifically protecting single-member LLC owners from full creditor foreclosure. Wyoming, Delaware, and Nevada are consistently cited as having favorable LLC protection statutes. Others offer significantly weaker protection, and your home state may be one of them. If you operate a high-risk business, hold significant personal assets, or are in a profession with lawsuit exposure, this is worth a direct conversation with a business attorney in your state. Mistake number 4 happens every single day inside small businesses across the country. Most owners never realize they have made it. It is signing contracts in your personal name instead of in the name of your LLC. When you sign a contract, the signature block is a legal statement about who is entering into that agreement. If you write only your personal name, you may have just bound yourself as an individual, not your LLC. If that contract ends in a dispute, the lawsuit may land directly on you personally, bypassing the business entity entirely. Every contract you sign should show the LLC name first, your name second, and your title as managing member or authorized signatory. Build this habit before you sign anything. Vendor agreements, client contracts, commercial leases, service agreements. Run through these 5 points on every one. This is 30 seconds of attention that can prevent years of personal liability exposure. And for any contract involving significant money or long-term obligations, have an attorney review the document before your pen touches the paper. Mistake number 5 is the quietest one on this list. There are no immediate warning signs, no letters from the state, no calls from an attorney. It accumulates silently year after year, until the moment you actually need your LLC protection and discover it has been quietly eroding the entire time. Courts assess whether your LLC behaved like a real, functioning, independent business over time. That assessment is based on documentation. If you are the only member, you still need to record that you held a meeting, even if it was just you sitting at your own desk deciding to sign a new client agreement. Document major purchases. Document changes in direction. Document any significant business decision with a simple written resolution. These records are the evidence that your LLC existed as a genuine entity separate from you personally. Here is how this scenario plays out in actual litigation. A plaintiff's attorney requests your corporate records during the discovery phase. You have nothing to show, no resolutions, no minutes, no documentation of a single business decision. The argument writes itself from that point forward. This was never a real separate company. This was always just a personal operation wearing a business name. That argument succeeds more often than it should, because the records that would defeat it were simply never created. I have seen every one of these mistakes in real cases, and the hardest conversation to have is with a client who believed they were protected for 5 years, who made business decisions, took on liability, signed contracts, only to learn in a deposition that none of the protection they thought they had was actually in place. When a court pierces the corporate veil, the legal wall between you and your LLC collapses entirely. Every asset you hold personally, your home, your savings account, your retirement portfolio, your vehicle, becomes reachable by creditors and judgment holders. This is not a fine or a regulatory penalty. This is the complete elimination of the protection you formed the LLC specifically to provide. And it is entirely preventable with proper structure and ongoing maintenance. The legal system does not reward last-minute preparation. When a lawsuit is filed, the clock on your credibility starts running backward. Courts examine what you did before the dispute, not what you fixed the week after you got served. Every hour you invest in proper LLC maintenance before a lawsuit is worth significantly more than any amount of legal maneuvering after one begins. Open a dedicated business bank account today if you do not have one. Get your operating agreement drafted or professionally reviewed. This document should not be a template downloaded from a free website. Look up your state's specific single-member LLC statutes. Your state bar's website or a 30-minute consultation with a local business attorney can answer this quickly. Fix your signature blocks on every contract you sign going forward. And set a recurring calendar reminder to document major business decisions at least quarterly. These 5 actions address every mistake on this list. 5 mistakes. 5 documented, court-tested legal theories that have been used to strip real business owners of the protection they built their LLC to provide. Every one of them is fixable right now, before any dispute begins. Identify the one on this list you know applies to your situation and address it first. You do not have to solve all 5 today, but you should not go another week ignoring any of them. The LLC is one of the most powerful legal structures available to a small business owner in this country. But it is a tool that requires proper use and ongoing maintenance. A structure left unattended does not hold. Your LLC is no different. Use it correctly, document it, fund it properly, sign for it correctly, and keep records, and it will do exactly what it was designed to do. Protect everything you have worked to build. If this video helped you identify even one mistake you need to correct, send it to another LLC owner you know. Drop in the comments which of these 5 was new information for you. That genuinely helps me know what to cover next. Subscribe for legal and tax information that is built specifically for small business owners. every single week.